Lee Heiss, lawyer guardian ad litem for the children.
Nastasia Thomas for the department.
Chelsea Grant with the department.
Michael McFarland representing father. Please introduce yourself.
Andrew Zick.
Brian Fry representing the mother, Erica Allen. Erica, say your name.
Erica Allen.
Thank you. All right, gentlemen, we've made some time for you to talk with your clients. I have a few questions to run through with them, like Native American heritage, and if there's any other matters. You're both nodding like you might know the answers to those. So let's start with Mr. McFarland. Do you know how your client would like to proceed?
We'd like to proceed with no contest, as 27C indicates charges, possible domestic violence charges, Your Honor. There's also allegations of drug usage. No Native American heritage. I'm not sure if there's a well, I do know there's a custody case pending because Mr. Fry represents a mother on that case.
All right, thank you very much. Has your client received a copy of the petition?
He has. We would waive the court reading it, Your Honor. We've got it.
Right, very good. All right. You've been advised, Mr. Allen, of your opportunity to deny or review the allegations today, and as I understand it, you are wanting to enter a no contest plea. Right?
Yes, Your Honor. My last name is Zick too, Your Honor.
Great, thank you. I'm sorry, I apologize. All right, Mr. Fry?
Yes, Your Honor. My client would also be requesting to enter a no contest plea due to possible pending domestic violence charges. As my understanding, there is no Native American heritage with children in this case. My client would waive any reading of the petition.
And there is a custody case pending, is that right?
There is, Your Honor, with a motion pending in front of Judge Wolsaver.
Does that concern, well, I guess let me ask you this, what's the current custody reflect?
My understanding, temporary custody with father, Your Honor.
Custody is joint, but father does have did obtain an ex parte motion for exclusive parenting time, which is still in effect. We were going to have a hearing on that, I believe, last week or the week before, but because this NA case had been filed, that was postponed because this would take jurisdiction anyway.
Okay. All right, Ms. Thomas, let's go to you a moment. Are you asking the court to look at removal today, or what is the department's position?
Your Honor, I just first want to check my audio. Sure, it's okay today.
Yeah, most. We heard everything almost. We'll let you know if it's a problem.
Thank you. And as far as removal, it is my understanding that the children are with grandparents, and we would like to make that formal through the removal order. I believe it's through a safety plan at this time. No, Ms. Grant, please correct me if I'm wrong.
No, that's correct. Okay, so kids are currently with a grandchild or grandparent under a safety plan. All right, well, before I accept the no contest plea, Ms. Heiss, do you find it to be in the interest of the children for me to do that?
Yes, Your Honor. I agree that there are potential criminal liability, and in addition, this would allow the parents to get into services without even a adjudication trial, which would benefit the children towards reunification even faster.
All right, Deputy Ames, if you could swear in Mr. Andrew Zick, Erica Allen, and Chelsea Grant. So, yes.
Thank you.
Yes, Deputy Ames is passing out a copy of your advice of rights in writing so that you can have a look at that today or at a later time if you need to. I trust both of you have talked to your attorneys about this, but I'm still going to go through some of your rights with you on record today before I accept a plea from either of you. So, Ms. Erica Allen, is it true you wish to enter no contest plea?
Yes.
Same for you, Mr. Zick?
Yes, Your Honor.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the petition or dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Mr. Zick?
Yes, Your Honor.
Ms. Allen?
Yes.
Has anyone promised you anything to get you to plead responsible, Mr. Zick?
No.
Ms. Allen?
No.
Are either of you under the influence of drugs, alcohol, or any other mental or physical condition that could impair your ability to understand what you're doing right now, Mr. Zick?
No, Your Honor.
Ms. Allen?
No.
Would you say your decision to enter a contest plea is one you've made of your own free will, Mr. Zick?
Yes, ma'am.
Ms. Allen?
Yes.
Testimony for the factual basis of the plea, Ms. Thomas.
Thank you, Your Honor. I would ask Ms. Grant to be sworn in.
Ms. Thomas.
Ms. Grant, how are you familiar with this matter?
I am the assigned ongoing caseworker through Children's Services.
And did you prepare the petition that is before the court today?
I did.
And how did you become aware of the allegations contained in the petition?
So over the course, since this case has come to the attention of the department, the original allegations came in December of 2022. And the family has had a case open for ongoing services since approximately January of 2023.
During your time as an ongoing worker, have you had the opportunity to speak with the family and work with them?
Yes, I have worked extensively with the family over the course of the case. I was officially assigned to it myself in March of 2023, which is when I became most familiar with this case. At that time, there was a lot of domestic violence going on. The family at that time, Mr. Zick was no longer in the home due to a no contact order that was put in place due to criminal charges for domestic violence. Residing in the home was Erica and their 3 children. Additionally was also Erica's older daughter, Katie, who resided in the home at that time. There had been, when I first came on, it had been reported to me that Erica had left the state and was going to be living in Illinois with all of the children. When I had sent a courtesy request to verify this, it had been reported that only KB was residing in Illinois and all of the rest of the family had moved back to Michigan and were once again residing in the trailer. That being because there was some dispute over the fact that Erica could not leave the state due to their custody order. And she was trying to get the kids enrolled in school in Illinois and wasn't able to do so. So she came back to Michigan. So she resided in the trailer at that time. And then she had first told me she was not going to, I'm sorry, it's been a long process. She at first told me she was not going to reside in the trailer before then telling me she was going to reside in the trailer. Eventually, we talked a lot about safety planning and those kind of things. They were still continuing to have contact between her and Andrew, including during the no contact part. Andrew was residing with a girlfriend of his during this time while him and Erica were separated, and she had driven to his girlfriend's house and tried to get him to come outside, and in the process of trying to get him to come outside, stole tools out of his truck and was charged with larceny. So it continued where then they would be apart, get back together. So this comes up right around the time in June. Mr. Zick was sentenced for his criminal domestic violence charge that was pled down, I believe, to an assault and battery. He was sentenced to domestic violence diversion program and I believe 52 sessions of counseling. As of this time, when I wrote the petition, he hadn't engaged in any of those services. Over the course of the month that it has been pending with the court, my understanding is he at least called and scheduled an appointment. I haven't been able to verify that. Following that, following him taking a sentence, the couple were back living in the trailer together. Andy's phone had been shut off and I was unable to locate and have a conversation with him. However, I had a very in-depth conversation with Erica regarding them, again, engaging in a relationship, safety planning, what that would look like if another domestic violence incident happened, engaging in services, filing the protection order, because she was very adamant at that time she didn't want him there. Engaging in, we've offered several services, even dating back to the original investigation, which included bringing more for therapy. There were domestic violence, Catherine Cobb, filing protection orders with the court. So following that safety planning and conversations with her, it's my understanding that the week after, there was some kind of maybe verbal altercation between the two, in which Erica again left the state. She did not notify CPS at that time. I later interviewed the children, who stated that mom and dad had gotten into another verbal argument, that she had left the state. She didn't tell them when she was going to come back. One child talks about how she didn't even say goodbye because she was so mad at dad, and that she took all of their belongings with them, including any food, so dad didn't have food, and also pillowcases and those kind of things, so that he wasn't able to provide for the kids. Again, she didn't report to us. Mr. Zick gave her a week to come back for the kids because they had CTECs that were scheduled. She did not return and appeared in court for her larceny charge, which she reported during her larceny charge that she was living in Illinois at that time. He did file an ex parte order that we, at that time, as a department, did support as a safety plan, that the kids remain here, they're able to go with their CTECs, have a little bit of stability, because this had been the second time that Erica had up and left the state. Following the ex parte order, all three kids that Erica and Mr. Zick, or Erica and Andy shared together, completed their CTEC assessments. The CTECs come back that there is extensive domestic violence between the two, that the kids are aware of, more than what has even been reported to us. There are incidents of a pumpkin being thrown in a truck. There's incidents of one of the parents I can't remember which one did it, but threw pizza at the other parent. The kids talk about how one parent will tell them all the horrible things that the other parent does to them, and vice versa. The kids are very conflicted because they love each parent, but then they will say, well, I only want to reside with one. And this has been ongoing. So following that, CTECs, when they came back, I had individual meetings with each parent regarding all the concerns related in the CTEC and what would need to happen moving forward. At that point, Erica had told me that her intention was to remain in Illinois, and Andy was going to remain here and fight for custody for the kids to be here. So I provided Andy with some resources that the kids could be put into counseling and therapy and those kind of things. I visited Andy the week prior to the incident that occurred. And I can't remember the exact date off the top of my head, but I specifically asked him, after interviewing a couple of the kids in the home, if Erica had been returning, because the kids had told me that she was moving back that day into the home, to which he denied that she was coming. Within that weekend is when it got reported to me, so that would have been the 28th maybe. That following Monday, it was reported to me from Mr. Zick that Erica had in fact moved back into the home. They had used drugs together all weekend. And then it was brought to the department's attention that they had also engaged in domestic violence over the course of the weekend.
And in short, the reasons for the request for removal come from the ongoing domestic violence, sort of this housing instability, or who is living, and then substance abuse. Was the one incident that you just reported or testified to, was that the only incident, or I guess not a time that you heard that substance abuse may be an issue for the parents?
No, that was brought up in the original investigation as well. There was drug screens completed for both parents during the original investigation, where only one parent did test positive for substances. He, at that point, kind of refused to drug screen after that until closer to when their custody hearing was. Ms. Allen, during their first custody hearing here in Michigan, had asked for a chance to retain an attorney, which was granted. However, she made several accusations of him using substances, supervising the children when he had them in care. So I did ask him to come in and submit for a drug screen during that time, to which he tested positive.
And as it relates to like CPS history and criminal history, how were you able to obtain those records?
So Illinois has not been easy to obtain like an official criminal background check. A lot of what we had to do was going onto their court public websites and searching both Erica and Andy's court records on the websites. Although I will say Mr. Zick has been pretty honest and forthcoming regarding his past criminal history.
Thank you. Your Honor, for purposes of the factual basis, I have no further questions of Ms. Grant. Thank you.
John?
Would I address you for parenting time for my client, or would that be the ongoing work?
So I am the ongoing worker, but it would transfer to foster care.
Oh, okay, that's what. Okay. Nothing further.
No questions, right?
Ms.
I have no questions, thank you.
Okay, thank you for your testimony. May return to your seat. All right, are you satisfied with the advice of rights and the factual basis of the plea, gentlemen?
I am.
Yes, Your Honor.
Yes.
Very good. The court is also, I further find that the plea is knowingly, understandably, and voluntarily made with a full understanding of the consequences, including the fact that the court will use the allegations in the petition as effectively and as true, in addition to the testimony that I've heard from Ms. Grant today, in evaluating whether or not it's appropriate to take jurisdiction of the parents in addition to the children. And I do find that the record supports one or more of the statutory grounds alleged in the petition are true, and that it is appropriate for the court to take jurisdiction. Specifically, I find the dynamics in the home reflective of the domestic violence. Reflecting the domestic violence poses a harm to the children's mental well-being. It indicates improper home or environment by reason of those actions, which could be classified as criminality. And that's, of course, also the reason the court accepted the no contact plea. So for those reasons, the court is taking jurisdiction of the family. We will be happy to look at the case services plan at the next hearing. And specifically for jurisdiction purposes, we're looking at MCL 712A.2B1 and 2B2. We have my criminal history with father and those dynamics with the children in the home. I'm sure we'll be looking at psychological evaluations, parenting classes, some other educational pieces and counseling for both of you, in hopes that we can help change those dynamics for you and for your children in the home. In the meantime, we need to talk about where the kids are going to be. So we've heard Ms. Thomas establish, first of all, that they're asking for an official order that would direct placement of these children with a relative. That would require an official removal from the court, and of course, an evaluation under the appropriate court rules. Ms. Thomas, would you like to do a brief argument on those before we ask the attorneys on that?
Thank you, Your Honor. I believe that your findings support the contrary to welfare requirements under 3.965. This family has been offered several services in the home, which have, unfortunately, they have not been able to benefit from. The children, the plan would be for the children to be placed formally with a relative caregiver, which is the most home-like environment for them. And from my understanding, they are familiar with these caregivers who have had them in their care for several weeks now. And so we would just request that this court issue that order. Thank you.
Well, Ms. Thomas, as I understand it, the children are in a relative's care with the agreement and consent of the parent under a safety plan. So I guess my main question for today that I'd like you to go ahead and answer for me is whether or not that provision or arrangement is reasonably available to adequately safeguard the children from the risk that was identified in the basis for the plea.
Jen, I think the main concern about a simple safety plan is that it does not permit the grandparents to enroll the children in school or get them care or sort of do those legal things that we may need. Right now, the parents are available, but should mom leave back to Illinois or dad become incarcerated or substance abuse become an issue again, we would just ask. That's sort of the safety measure in our insurance policies. So that is why we would ask for the formal removal.
I know that will also trigger some funding for the grandparent. Is that anticipated?
I am not entirely positive on that. Generally speaking, that is my understanding. I can leave that to Ms. Grant if she's able to speak on that.
Yes, our fictive kin worker can work with them in opening additional funds and things that they will definitely qualify for if the children are in the foster care order.
All right. Mr. Pratt.
Yes, Your Honor. I mean, the children are placed with grandparents right now through a safety plan. My client did agree with that safety plan and consented to that placement. My client has been getting parenting time since the children have been placed there. I think, from my understanding, things have been going well. Just understanding that my client intends this to be a very temporary arrangement, and she's going to do, everything possible to get the kids back. But as of right now, I think our position is that that would be an appropriate placement.
All right. Mr. McFarland.
My client supports the relative placement, and he also would support his continued parenting time, which as mom is uneventful as far as there's no issues.
Ms. Heiss, what are your thoughts?
Yes, I believe it to be in the best interest of the children. The length of the domestic violence and the length of the time this home has been unstable is substantial. They are very young. They have been in the presence of many of these domestic violence situations. I think that this placement will demonstrate to them that there's going to be change. And I think it's important for them to be stable. Grandparents are willing, and visitations have been going well. Thank you.
Does anyone wish to offer any testimony on any of this before I make my analysis?
No, thank you.
Your Honor.
No, Your Honor.
Very well. Well, under MCR 3.965, as a request to place children into foster care, the court has to look at subsection C2. Whether or not custody of the children in this case with the parent presents a substantial risk of harm to the child's life, physical health, or mental well-being that has been established during the taking of the plea for the very reasons that Ms. Heiss articulated, as well as the court articulated as the basis for jurisdiction. I do see that we have a provision of service or arrangement available to the children at this time that secures them from the risk on a temporary basis, but I do think that Ms. Heiss's point is well taken, as well as the fact that the family is not looking at other options at this point, at least, such as a power of attorney or a limited guardianship or something of that nature. So I don't think that there is any other service or provision at this point other than the official removal of the court, reasonably available to adequately safeguard the children from the risks of harm associated with the tumultuous relationship, the transiency of the parents, and the length of time of the patterns, as Ms. Heiss pointed out. Continuing the child's residence in the home with the parents is contrary to the children's welfare at this time, and I give a lot of credit to both parents for acknowledging that and asking for a time to try to change direction. Under D, I do think reasonable efforts were made to prevent or eliminate the need for removal, and Ms. Grant went through those very specifically on the record with us today. The prior services, the analysis, the arrangements have all been insufficient to break that cycle as of yet. That does pose a serious risk of harm to the children. I also see that the arrangements that have been made with the relative or fictive kin, I should say, are adequate to safeguard the children's health and welfare. That was as a result of the initial vetting of the department and asking for the parents to cooperate with the safety plan. And so for those reasons, I do find that it's necessary to order the children into placement It is contrary to the children's welfare to remain at the home of the parents for the reasons that the court has visited a number of times already on the record today. There will be a requirement for the department and the agency to continue to make reasonable efforts towards a goal of reunification in this case. I will look forward to having a look at the case services plan along with all of you at our initial disposition hearing, which has been scheduled for August 18th.
August.
I'm sorry, that's October. No. So the 8th, 10/18 and 11:30.
Your Honor, may I address one more thing? There is a no contact provision of mother's bond through a larceny charge. However, my experience with the criminal courts, they're not always respective of what we're trying to get done here. I would request that the court reiterate a no contact provision between the mom and dad just until we can get some progress made.
Any objections?
Your Honor, my client has sold the trailer to mother, and he needs to recover his personal stuff. I suggested to him he could take a police officer to do that. He agrees not to initiate contact, but he does need to go to that property to recover some of his goods.
I would not consider a civil standby with an officer on a one-time retrieval of personal property to be a violation of a no contact provision if I entered it. Does that help?
It does.
Your Honor, my client was sentenced this morning, Judge Morgan, on that. Judge Morgan did make a term of my client's probation, a no contact between herself and Mr. Zick. He did indicate that if Mr. Zick requested that to be dropped, he would drop it, but until Mr. Zick made that request, the no contact would remain. So it's not a bond condition anymore, it's actually a probation term. So.
Well, this would create a mutually obligatory situation.
Yep. So, I just wanted to correct that it's not a bond term anymore. It's actually a sentence. It was a term of the sentence of probation, but we would not object to making that an order of this court as well.
Very good. All right, so my order will reflect that then. Who will be reaching out, Ms. Grant, will it be you, or who will be doing hopefully an FTM about the case services plan?
I believe it's going to Catholic Charities. I'm not sure who the exact
Catholic
word
Charities,
is.
Do we have anybody from, okay, so maybe Kristen Smith, are you going to be taking over, Ms. Smith?
Yes, I'll be the assigned foster care worker.
All right, very good. So we'll ask you to stay on for a few minutes afterwards to make sure that you have mother and father's information so that you can schedule that FTM about case services.
Great, thank you.
Very good. All right, so Ms. Smith will be in touch with you then to put together that plan. You're supposed to have a say in it, so please look at it. And it will also be important for you to look at it because it's what I will be looking at to see if you've made progress in the services so that we can see whether or not it's safe to return the children to you. Any questions? All right. Okay, well, I'll have this order out to you in a few minutes, but that's all for the record for today.